The International Criminal Court is now in session.
Good morning, everyone. This is a preliminary hearing of Pretrial Chamber 2 in the case of the prosecutor versus Lord Blaze. I believe that all of you are well familiar with the format of this morning's hearing and the subjects to be discussed. So without further ado, I will call upon the prosecution to present itself, indicate the timing of the speakers to the extent that they're allotted, and remind you that you have 25 minutes in total for your initial submissions and 5 minutes for your rebuttal submissions. So please proceed at your leisure.
May it please the court. My name is Mara Ionitsa, and I appear today on behalf of the prosecution. In 14 minutes, I will be addressing firstly our submissions on jurisdiction and secondly our submissions on admissibility. My co-counsel, Mr. Roger Brown, will be using the remaining 11 minutes to address our submissions on interest of justice and lastly on the criminal responsibility of Lord Blaze. Firstly, the prosecution submits that the court has jurisdiction over the case against Lord Blaze. Because the requirements for temporal jurisdiction under Article 11 are fulfilled, and the requirements for both jurisdiction ratione loci and ratione materiae under Article 12, paragraph 2 are fulfilled, the issue at hand is with regards to subject matter jurisdiction. The court has jurisdiction over crimes against humanity, which includes the crime of enslavement, when committed as part of a widespread or systematic attack directed against a civilian population with knowledge. Therefore, the prosecution will prove two further points. A, that the constitutive elements of enslavement are fulfilled, and B, that the contextual elements of crimes against humanity are also present in this case. For point A, with regards to constitutive elements, the crime of enslavement is defined as the exercise of any or all powers attaching to the right of ownership. This includes imposing a deprivation of liberty on the victims, reducing the victims to a servile status, and also obtaining forced labor from the victims. The prosecution submits that it is exactly those factors that are present in the case against Lord Blaze. That is because we have the detainment of at least 30,000 civilian earthbowers in Center Ring. We also see that the servile status has been imposed. That is because the free will and the consent and the autonomy of those detained has become completely irrelevant in the face of psychological force and threat. Lastly, we see that there is also the obtainment of forced labor from the earthbowers on the part of the Far Republic. That is because the earthbowers are made to work, they are subjected to very harsh, grueling working conditions. We see 12 hours a day, every day of the week, with only a 30-minute lunch break. And those that refused or were too weak to work would be automatically punished by having to sit all day outside in the snow. Moving further to the contextual elements of crimes against humanity. As per the Côte d'Ivoire decision at paragraph 29, the contextual elements are as follows. There must be an attack directed against a civilian population. The attack must be in pursuance or in furtherance of a state or organizational policy. The attack must be of a widespread or systematic nature. There must be a nexus, and lastly, the attack must be carried out with knowledge. With regards to an attack directed against a civilian population, an attack means, as per Article 7, paragraph 2A of the Rome Statute, the multiple commission of acts of enslavement. The prosecution submits that this is fulfilled in our current case because, as the prosecution proved in our first point, we have the enslavement of at least 30,000 people from at least the period of June 2018 until the centers were closed. This number could go as high as 100,000 people that were detained. With regards to the requirement of a policy, the prosecution submits that we have.
Excuse me, counsel. I have a question in relation to your submission on the definition of attack. You referred that the attack is the multiple commission of the acts of enslavement. This bench should consider that this court should only consider the act of enslavement for the contextual element. How is this? If you can clarify in this respect, thanks.
Thank you, Your Honor. I have 2 points in response to Your Honor's question. Firstly, we could also look at a definition such as the one given in the Bemba case judgment pursuant to Article 74 at paragraph 151, where the court considers that an attack can also mean any kind of mistreatment directed against a civilian population. So we can look at the broader framework of the whole conflict that have been happening in the Far Republic since 2015. However, on our second point, the prosecution mainly uses what has been happening since 2015 in order to prove the next contextual element, which is that of policy. Because a state policy requires factors such as patterns of violence, institutionalized oppression, and the failure to bring those responsible to justice. The prosecution submits that those factors are present in our current case. We see at the broader scale that since 2015, the Far Republic has been on a mission to end the semi-autonomous status of Black Mound and to fight against the Earth Powerist culture. We see that all public Earth Power ceremonies and rituals were canceled, arrests were carried out in regards to Badger moles, the priests of the Earth Power's religion, and also house searches have been routinely carried out. Therefore, these factors that Your Honor asked about, we use in order to prove this policy. Furthermore, with regards to the nature of the attack must be, the prosecution submits that this attack is widespread in nature. As per the decisions in Bemba at paragraph 83 and Côte d'Ivoire at paragraph 53, widespread means an attack of large scale that is massive and carried out with considerable seriousness and collectively. In our current case, again, we look at the suffering of somewhere in between 30,000 and 100,000 people, and that is only in Center Rig. And the attack, the seriousness with which the attack has been carried out can be seen in how the BNS operates in order to strictly transport, survey, and punish whoever they deem as the enemy. Moving on to the requirement of a nexus. This requirement is meant to exclude isolated acts. However, since the enslavement that took part in Center Rig is part of the broader, larger scale whole rehabilitation, so-called rehabilitation program instituted by the Far Republic and by the Far Republic, this act of enslavement is not isolated. Lastly, we move on to the requirement of knowledge. Knowledge means that the perpetrator was aware of the widespread attack and that their actions were part of the attack. And as per the of crimes document in paragraph 3 of the introduction, we see that this knowledge can be inferred from the circumstances. The prosecution submits that Lord Blaze had knowledge of what was happening in Center Rig. That is because he was the one who signed the executive order that gave BNS the power to take all necessary measures to end the conflict and bring back security and stability to the Far Republic. We see under the same executive order that he was to receive regular reports from the PNS. And lastly, we see that he was in direct contact with the Minister of Interior, with the person directly responsible for how the centers were run. Therefore, the prosecution submits that Lord Blaise was well aware of what was happening, especially since it was under his administration that the conflict in Black Mound first started. If the prosecution, if the bench does not have any questions on with regards to jurisdiction, the prosecution will move further to our point on admissibility. The prosecution submits that this case is admissible for two reasons. Firstly, law number 14 of the Far Republic is inconsistent with the Rome Statute. We see that the objective and purpose of the Rome Statute, and therefore of this court, is to end impunity for the most serious crimes of international concern. The prosecution submits that amnesty laws, which prevent this impunity from being, which prevent the court from bringing an end to this impunity, are inconsistent with the Rome Statute. And therefore, by applying law number 14, the Far Republic is in breach of its duties under the Rome Statute. However, on our second point, if this court is willing to accept the legitimacy of law number 14, the prosecution submits that a trial is still permitted under the exceptions in Article 20, paragraphs 3A and 3B. In these exceptions, we see that the case is admissible where either the national proceedings were done to shield the person from prosecution, or the proceedings were done in a manner that is inconsistent with an intent to bring those accused to justice. And this is exactly what is happening with law number 14 as it is applied to Lord Blaise. We see that Lord Blaise went from being the one regarded as, let's say, the hero who is trying to bring peace to the Far Republic. Overnight, he went to the one accused for those grave crimes. Therefore, when he found himself in this situation, he sought amnesty. And he didn't seek amnesty because he was sorry for it or because he wanted to help the Earth powers in any way. He sought amnesty in order to protect himself. And this, applying the court's judgment in the Al-Sanusi case at paragraph 230, subparagraph 2, means that the national proceedings were done in a manner that were inconsistent with bringing Lord Blaise to justice. Because as elaborated by the court in Al-Sanusi, what Article 20 requires is that the accused is not tried appropriately in order to establish criminal responsibility. At no point is Lord Blaise held accountable for the sufferings of those tens of thousands of people.
Excuse me, counsel, but what was the outcome in that case, in the case of Al-Sanusi, that you are bringing to this court?
Thank you, Your Honor. The case was indeed found admissible by the court. However, the prosecution distinguishes this from our current case. The problems raised by the defense in Al-Sanusi centered more on the rights to a fair trial, focused mainly on the rights to a fair trial and due process of the accused, whilst here we see that these rights were respected and that the proceedings still stand as proceedings that unjustly benefit the accused. Therefore, I will conclude my submissions here, reiterating the fact that the court does have jurisdiction over this case and that the case is admissible. If there are no further questions, I will rest my submissions here. Thank you.
Thank you, counsel. Seeing no further questions from the bench, please proceed.
Mr. President, Your Honors, may it please the court. My name is Roger, and I will be making the latter two submissions for the prosecution. On the first of those submissions, I submit to this court that the case against Lord Blaze is in the interest of justice. Now, in furtherance of this submission, I will be making 3 points. The first point is that the prosecution does not have a burden to prove that the case against Lord Blaze is in the interest of justice. Now, in support of this point, the prosecution highlights the 2017 pre-trial decision of the situation in the Republic of Burundi, where at paragraph 91, the pre-trial chamber noted that Article 53(1)(c) is a negative test. Therefore, where the prosecution had affirmatively answered the question, the court agreed and did not review the decision. We submit in this case, similarly, that where it is that the prosecution has indeed determined that the case against Lord Blaze is in the interest of justice, no further burden rests on the prosecution at this stage to prove that the case against Lord Blaze is in the interest of justice. On the second point of our submissions, we, the prosecution, submit that this chamber does not have the power to preclude, indeed, does not have the power to move forward with the prosecution that has been initiated by state referral. Now, Your Honors, we submit that the nature of Article 14 is such that the prosecution of an individual, indeed the prosecution in itself, is under an obligation to investigate and prosecute where it is that a matter has been referred under Article 14. Now, the defense may argue that both Article 15 and Article 14 import a judicial considerations or a judicial overview. We submit in the alternative. Now, this is on the footing of the situation in the Republic of Kenya, as well as the 2020 appellate decision of the Republic of Afghanistan, where at paragraph 32, the appellate chamber noted that Article 14 and Article 15 are in contradistinction. It went further to note at paragraph 32 that in the absence of a referral, the pretrial chamber's authorization is required. Therefore, we, the prosecution, submit that considering that the case against Lord Blaze has been referred to the prosecutor by the Earth Nation, that the pretrial chamber at this stage is not empowered to review the decision to prosecute.
Is it relevant that the referral, is it relevant, counsel, that the referral has been made by a country other than the one whose in which the crimes occurred and whose jurisdiction actually is now being discussed? And if so, how?
Certainly, Your Honors, and we note that Article 14 does not impose a distinction between referral by the state and self-referral as between referral by other states. We go further to note that the proximity of the Earth Nation to the Fire Republic demonstrates indeed that this is a well-informed referral, noting specifically that the Earth Nation is the primary group for which the Earth Bowers were located in Black Mountain, a semi-autonomous state, up until 1925, and is aware of the situation that has been happening in the Fire Republic as of 2015. Therefore, we submit, and this indeed brings me to my third submission, that there are substantial reasons to believe that the prosecution of Lord Blaze is in the interest of justice. And we, the prosecution, make this point on the presumption that the court is not minded to find that it may not review the decision, that it may rather review the decision. And in addition to the fact that it's a state referral, not only not a self-referral, but by a neighboring state, but this is compounded by the fact that the prosecution of Lord Blaze is conformed with the object and purpose of the Rome Statute, which is to put an end to impunity for serious crimes. Second, Your Honors, we submit that considering the extent of the crimes of enslavement, that it is imperative to prosecute Lord Blaze for the crimes of enslavement. Now, in the 2003 decision of the situation in Côte d'Ivoire, the pretrial chamber noted that the 602 victims of rape, murder, and pillage demonstrated the seriousness of the crime and the need for prosecution in the interest of justice. Moreover, in our case, Your Honors, we have at least 30,000 earthborers and at most 100 earthborers who are victims of enslavement. And for these reasons, we submit to this court that the prosecution of Lord Blaze is in the interest of justice. Now, unless I'm otherwise directed, Your Honors, I will move to my second submission, that being that Lord Blaze is criminally responsible for the crimes of enslavement under Article 28B of this Rome Statute. Now, in support of this submission, I will make 4 points before this court. First, that there is a superior subordinate relationship that exists between Lord Blaze as well and between Ursa Uzila and the BNS. And we submit that this exists both in a de jure capacity and in a de facto capacity. Now, in the 2016 of the prosecutor against Bemba Gombo, the pretrial chamber noted that where it is that a de jure link exists between the superior and the subordinate, then a relationship ipso facto exists. Now, we highlight, Your Honors, the fact that Lord Blaze is the mastermind, indeed the president of the Far Republic, and Ursa Uzila was appointed as the Minister of Interior by an executive order. In fact, Your Honor, not only is there a de jure link, there is also a de facto link. Now, we submit that on the authority of Exhibits 1 and 2, that Ursa Uzila was indeed acting with Lord Blaze as her superior. Now, the defense may argue indeed that the Exhibits 1 and 2 are circumstantial. Indeed, we submit in the alternative, Your Honor, as well as we go further to note that nothing precludes this court from taking into account circumstantial evidence where it is that there are reasonable grounds to believe that a crime against humanity has been committed. And we submit that a crime against humanity has been committed as given the crimes of enslavement that was
Excuse
happening in Century. On the second point of our submissions, Your Honor, we submit
Excuse me, counsel. I have a question in relation to this point, because you are referring to the case of Bemba. And as you probably know, this situation, we are under a different part of the Rome Statute in superior responsibility. So this bench would like to know, in the understanding of the prosecution, what is the difference between a civil superior and a military superior? And what is the standard that this court should follow in this case? Thanks.
So, Your Honor, thank you. Much obliged. Your Honor, you've asked me 2 questions and I will answer them in chronological order. On the first question, Your Honor, we note that the article on military superiors and Article 28 are legally contiguous. And while indeed there is no jurisprudence for the courts to follow regarding Article 28, we submit that on the authority of the ICC's judgment in Bemba, that this court can indeed note that this court can apply a similar test regarding superior commander as it does for military commander. And second, Your Honor, we note that the relevance of the military, on the second question, that the relevance of the military commander of Article 28 of the relationship, to rephrase, the relevance of the superior subordinate relationship is one that is excluded by that covers all bases that the very narrow limitations of the military commander relationship does not. And in fact, it's a more contemporary understanding of how crimes against humanity, and indeed general crimes as provided for the Rome Statute operate, that it need not exist in a military capacity. And for these reasons, we submit that Lord Blaze, that the Vemba case is applicable here. We go further, Your Honors, to our second submission, that Lord Blaze has and had effective control over Ursa Uzila. Now, effective control, Your Honors, is demonstrated and proved by Lord Blaze's ability to prevent or punish criminal conduct. Now, what is this degree of control that Lord Blaze exerted? We submit that there is a concatenation and a deluge of evidence on the facts to support this. Lord Blaze appointed Ursa Uzila, as is noted in paragraph 7 of the facts. He could direct her where to send the prisoners, as is noted in paragraph 21 of the facts. Indeed, Lord Blaze eventually ordered an end to the conflict. Lord Blaze ordered Ursa Uzila to send him reports, and Lord Blaze managed Ursa Uzila's actions throughout the crimes and her time at Century. And indeed, he told Ursa Uzila to take all necessary steps. For these reasons, we submit that Lord Blaze had effective control over Ursa Uzila. Now, on the third point of our submissions, Your Honor, I submit that Lord Blaze had constructive knowledge of the crimes. Now, we submit, Your Honors, that constructive knowledge is one in which Lord Blaze had either actual knowledge or conscious disregard. Now, earlier, Your Honors, I pointed to Exhibits 1 and 2, which demonstrated a communication between Lord Blaze. And indeed, I noted that Ursa Uzila had sent Lord Blaze reports. But, Your Honor, the defense may argue that this evidence is sporadic, inconsistent, one-off, singular, and perhaps struck as freakishly as lightning. But this does not jeopardize, Your Honors, I see that my time has expired. Might I be granted a minute to
you can have 30 seconds just to wrap up your thought. Thank you, counsel.
Certainly, Your Honors. And we submit that the very inconsistent nature, indeed, of the communication is the crux of the prosecution's point. That being that where at paragraph 7, Lord Blaze told Ursa Uzila to take necessary means, he was under a higher obligation to ensure that the steps taken by Ursa Uzila were properly, that Ursa Uzila had taken the proper steps. And where he failed, Your Honor, we submit that he consciously disregarded, he consciously disregarded, and as such, the commission of the crime, and as such, he's criminally responsible. Your Honor, I see that my time again has expired. It was a pleasure appearing before you and to assist you. And unless I'm otherwise directed, these are my submissions.
Thank you very much, counsel. And seeing no questions from the bench, I will now ask the defense to present its response and to indicate the allotment of time between counsel. Thank you.
Mr. President, Your Honors, may it please the court. My name is Elias Kong, and alongside my co-counsel, Ms. Hannah Tan, we appear on behalf of the defense. I will address this court first for 13 minutes in response to the first two issues relating to the jurisdiction of this court and admissibility of this case. Ms. Tan will then address this court for 12 minutes by responding to the remaining two issues concerning the interest of justice and Lord Blaze's superior responsibility. In light of this, I have two submissions to make today. First, that this court does not have the subject matter jurisdiction to hear this case because the specific element of enslavement has not been made out. Second, that this case is in any event inadmissible pursuant to Article 17(1)(c) because Lord Blaze has already been validly tried before a Fire Republic judge. With that, I begin with my first submission on subject matter jurisdiction. Now, as a preliminary point, I wish to first address the prosecution's argument on the contextual element of an attack. Now, they define an attack as any kind of mistreatment, and they cite the trial chamber's decision of Bemba for this proposition. Unfortunately, they failed to bring to this court's attention that this definition was expressly rejected by the appeals chamber subsequently at paragraph 25 of its decision. Indeed, an attack need not necessarily be military in nature, and it may involve any form of violence against a civilian population. This was held by the 2014 trial chamber in its Katanga decision. And therefore, we accept that there was an attack, which is why we have focused our submissions today instead on the specific element of enslavement. And on this point, the prosecution relies principally on two main factors to establish the crime of enslavement. They are one, forced labor of the detainees, and two, the inhumane working conditions within center rape.
Counsel, can I just stop you for one moment? You just said that you accept there was an attack. Can you indicate what acts you say are constitutive of this attack?
Mr. President, we say that the attack spanned the full duration of the 3 years, from the initiation of banning of certain earth bowers rituals all the way up to the period where enslavement took place. And this formed the broader context in which enslavement took place. Now, that is not the crux of our submission here today. We are saying that the contextual elements, although the contextual elements were made out, the specific element of enslavement fails to be established on reasonable grounds. Now, the two factors the prosecution relies on, whether individually or taken together, fails to demonstrate reasonable grounds for believing that the crime against humanity of enslavement has taken place. First, the prosecution's reliance on the factor of forced labor in itself is incorrect as a matter of law. Now, involuntary forced labor in and of itself does not automatically amount to enslavement. In the context of prisons and detention centers, compulsory labor is often employed as a form of corrective punishment imposed on detainees. Indeed, detainees can be made to work under reasonable working conditions. And this was held by the ICTY in its trial chamber 2002 decision of Chrono-Yalaj. And therefore, the true question here is not whether forced labor was made out per se, but rather whether this labor took place under such harsh working conditions which made out the crime of enslavement. And this is, in essence, a separate factor that the prosecution relies on. Now, on this factor, the prosecution argues that the detainees were mistreated and this amounted to such harsh working conditions. Unfortunately, this argument suffers from a simple yet crucial logical gap. It is not enough for the working conditions to have been bad. They must have been so bad that it evinces an exercise of any or all of the powers attaching to the right of ownership. Now, this is the defining characteristic of enslavement, clear from the express wording of Article 72C of the Rome Statute. And to identify this defining characteristic of ownership, there must be facts pointing to the victim being reduced to a commodity, such that he becomes an object of enjoyment of possession. This was held by the ECCC Appeals Chamber in its 2012 decision of Kind. Now, most cases do not demonstrate such a level of commodification, especially so in the context of detention centers. And in cases which did, the facts there were particularly egregious. For instance, in the case of Kind itself, detainees, both adult and children alike, were used as farm animals for plowing fields. And when they fell from exhaustion, they were beaten and threatened to keep going or risk disappearing. Now, as a result of this inhumane cruelty, a majority of the children died from sickness and hunger. Now, while they were worked to death quite literally during the day, at night, they were shackled like animals, literally treated as commodities and objects of use. Now, the facts of the present case are far removed from such commodification. If we turn to the description of center rape by one Haru Rock, we see that the detainees were worked 12 hours a day, and in the face of defiance, they were punished by standing outside in the snow. Now, we acknowledge that these may not have been the most ideal of working conditions, but this does not mean that they have been reduced to a mere commodity, and it does not mean that there was an exercise of ownership powers over them. Ultimately, Your Honors, these allegations of harsh treatment stemming from a single witness account does not demonstrate that.
Sorry, may I interrupt for a minute? You mentioned Mr. Haru Rock. Is this evidence and that what we have heard from Mr. Rock credible at all. Who was Mr. Haru Rock?
Your Honor, we first note that at this stage of the proceedings, the standard of proof required is reasonable grounds, and therefore typically this court does not inquire into the credibility of witness accounts at this specific stage. But our point goes beyond that. We are saying that even if we admit Haru Rock's evidence, his description of Centeric still does not demonstrate an exercise of ownership powers necessary to make out the crime of enslavement.
My question, maybe I mispronounce this, is was he an enemy in the legal sense of the paragraphs, the articles you mentioned, or was he more or less a terrorist, a member or even a leader of a terrorist organization? And would this change your submission?
Your Honor, we note that Haru Rock was a leader of the Ang opposition. And we say that on the point of whether this affects our submission, it only goes toward the factor of civilian population, which we are not contesting in our oral submissions today. Our point here simply is, regardless of the status of the detainees, the facts of Centeric do not demonstrate an exercise of ownership powers, which is a crucial element to establish the crime of enslavement. Now, that is not the only problem with the prosecution's arguments, as this case is, in any event, inadmissible before this court. Now, the prosecution argues on this second submission. The prosecution argues that the prosecution argues under this second submission that the amnesty cannot apply to a crime against humanity. Your Honors, that is not our submission before this court today. We are not saying that the effect of the amnesty itself prevents any further prosecution by this court for crimes against humanity. All we are saying is that the judicial process of granting an amnesty amounts to a trial, which invokes Article 17(1)(c) of the Rome Statute. Now, the crux of the debate here centers on the definition of a trial and whether the judicial process of granting an amnesty can fall within this definition. In this regard, the definition of a trial should not be so narrowly interpreted as to require a judgment on the specific merits of a case. Indeed, this narrow definition cannot possibly uphold the object and purpose of the Rome Statute, which enshrines the principle of complementarity. In this regard, Article 31(1) of the Vienna Convention on the Law of Treaties provide that a treaty shall be interpreted in its context and crucially in light of its object and purpose. Now, we note that the prosecution has identified ending impunity as one of its objects, but they have turned a blind eye to another core object of the Rome Statute, which is to uphold the principle of complementarity in order to respect the sovereignty of its state parties, which is why paragraph 10 of the preamble states that the ICC shall be complementary to national criminal jurisdictions. Therefore, to uphold this principle of complementarity, an accused should be deemed to have been tried not only when there is a judgment on the merits, but also when a court makes other final decisions relating to criminal proceedings. The critical touchstone should be an exercise of final criminal jurisdiction, and there is no principled reason why this must require a judgment on the merits. Here, the amnesty, which effectively terminated and prevented any further criminal proceedings, clearly constitutes a final exercise of criminal jurisdiction, which is sufficient to invoke Article 17(1)(c). And so the true question here is whether the safeguards under Article 23 are invoked, and not whether Lord Blaise has been tried or not. Now, on this point, the prosecution has argued that the amnesty amounted to an act of shielding Lord Blaise from criminal responsibility, and therefore invoked the exception under Article 23(a). Unfortunately, this argument has left out a crucial requirement under Article 23A. Now, it is not enough for the domestic proceedings to have in fact shielded Lord Blaze. It must have been intended to shield Lord Blaze, and this requires proof of bad faith. Now, the bad faith intent to shield can only be shown by intentional omissions or serious deficiencies in the conduct of the proceedings. On the facts here, the judge had conscientiously determined if the set of conditions were met before granting Lord Blaze an amnesty. Clarification 6 to the facts further crystallizes this, as it states that the amnesty was lawfully granted. Indeed, there is no evidence that the judge or Fire Republic had acted in bad faith. And therefore, we say that this
Excuse me, counsel, I have a question in this regard, because you're mentioning there's no evidence in the behavior of the judge, but the judicial control of this amnesty that was asked by the president was done in 4 days. So would this meet the standard of this court to say that this was not with the intention of shielding the Lord Blaze?
Your Honor's concern as to the time it took for the amnesty trial is indeed shared by the Rome Statute drafters, which is why they put in place the exception under Article 23A. Now, this exception requires proof of bad faith, as Your Honor rightly pointed out. And the mere fact that the trial was concluded in 4 days is completely understandable and does not go toward proving bad faith, which is a very serious allegation. Now, this 4 days period, when seen in context of the conditions the judge was assessing, is completely understandable. Now, the conditions he had to assess were 1, disarmament, and 2, an apology. I first note that my time is up. If I may just have 30 seconds to answer this question.
Counsel, you can ask your co-counsel whether or not you have those 30 seconds.
Much obliged, Mr. President. Now, the conditions that the judge had to assess were 1, disarmament, and 2, an apology. And these conditions are relatively simpler determinations, which is why the 4 days time period is completely understandable in this context. Now, unless I may be of any further assistance, I conclude my submissions.
Thank you very much, counsel.
Mr. President, Your Honours, may it please the court. As earlier introduced, I am Hannah Tan, and I act on behalf of the accused, Lord Blaze. I will address Your Honours on the next 2 issues concerning the interests of justice and Lord Blaze's individual criminal responsibility. Your Honours, the current conflict has resulted in immense violence, brutality, and suffering. That both sides of the conflict have finally come together to peacefully settle the matter is no small feat. Thus, while this court does seek to ensure that the most serious of crimes do not go unpunished, this must be balanced against considerations of domestic peace. To that end, I make 2 submissions. First, prosecuting Lord Blaze would not be the interests of justice pursuant to Article 53. And second, even if the crime of enslavement is made out, Lord Blaze is not individually responsible pursuant to Article 28. Now turning to my first submission, the prosecution's case against Lord Blaze does not serve the interests of justice. Now I note that Mr. President had earlier queried the prosecution on whether a referral made other than the country where the crime occurs actually affects the current situation. And in response, the prosecution said that given the proximity of the Earth nation and that the Earth powers were the primary group inhabited there, this is significant. However, Your Honours, this must be read in light of the entire context occurring here in Fire Republic. Now, in particular, there was a peace process already established, and given that it was a third party, the Earth Nation, who referred the situation to this court and not the parties themselves, this fails to give effect to the current peace process in place. And in fact, the destabilization of the peace process is a factor which the prosecution has appeared to conveniently leave out. Now, in this regard, both the Eng and the Far Republic have finally agreed to settle the matter peacefully. The carefully negotiated agreement saw the creation of both a truth commission and conditional amnesty, as found at paragraph 17 of the facts. And importantly, this was not a mere one-sided agreement. Instead, both parties had ample opportunity to negotiate the terms of the agreement. In particular, it was agreed that Black Mount would remain semi-autonomous, and this is the very thing which the Eng wanted since the beginning in their fight for self-determination. Should this court now choose to proceed with Lord Blaze's prosecution, disregarding what both parties have agreed to, the painstakingly negotiated agreement is likely to break down, and the potential instability which ensues will cause yet another period of violence to erupt. Hence, proceeding with Lord Blaze's prosecution would destabilize the current peace process, which would not be in the interest of justice. The final point the prosecution made regarding the interest of justice is that prosecuting Lord Blaze would be in line with the object and purpose of the Rome Statute. Now, in this case, the defense acknowledges that the Rome Statute does indeed have the goal of ending impunity via prosecution. However, we submit that there also exists the broader goal of ensuring peace and security. And this is borne out by the very preamble of the Rome Statute, which states that this court seeks to prevent crimes which threaten the peace and security of mankind. Hence, it is submitted that a broader interpretation should be adopted. And in addition, this would be supported by the travaux préparatoires of the Rome Conference. The drafters had recognized that criminal prosecution may at times hinder the achievement of peace. Their issue was merely the scope of considerations which could fall under the interest of justice. As such, they deliberately left it undefined. What is key, however, is that they did recognize that prosecutions could very well hinder the achievement of peace. Now, turning to my second and final submission, even if the crime of enslavement is established, Lord Blaze is not individually responsible pursuant to Article 28B. Now, in this regard, Your Honours had earlier queried the prosecution on what exactly is the difference between civilian superiors under Article 28B and military commanders under Article 28A. And indeed, this is a valid question which has been discussed widely in the jurisprudence. Now, on that note, this also relates to the relevant mens rea which must be proven in our case. Now, where civilian superiors such as Lord Blaze are involved, Article 28B expressly requires the higher mens rea of conscious disregard. And this standard is akin to willful blindness or recklessness, which does not include mere negligence. And this can be derived from the case of Celebrity from the ICTY. Here, Lord Blaze as a civilian superior does not exist in as tight a chain of command or hierarchy as military commanders. And it is the position of the drafters that they intended to impose the higher mens rea upon military superiors, which Lord Blaze is not. And in proving the mens rea of conscious disregard, we note that the prosecution earlier relied on only one fact, that Lord Blaze had signed the anti-extremism order, which gave Minister Azela the power to take the necessary measures to preserve national security. However, all this points out is that Lord Blaze was the president of our republic giving orders to his subordinate. However, what the prosecution has failed to point out is that this factor cannot stand on its own, because while an individual's hierarchical position may be a significant factor showing knowledge or conscious disregard, the mens rea cannot be presumed from this status alone in the absence of other factors. This was held by the ICTY in the case of Blaskic at paragraphs 56 to 57 of the accused judgment.
Excuse me, counsel. Sorry, I have a question in relation to this relationship, superior responsibility between the Ministry of Interior and the forces, because here from paragraph 17, it's clear that the Lord Blaze decided to put an end to the conflict and also ordered the BNS to start the peace negotiations. So there, he had a kind of authority to order them start these negotiations. So you are not considering this for saying, indicating that there was a relationship between the forces and the president.
Your Honor, we are taking the prosecution's case at its highest, such that we acknowledge that there was indeed a superior subordinate relationship. However, we submit that the critical element of knowledge or conscious disregard is what the prosecution has failed to prove on reasonable grounds. And that is what I have addressed this court on. Now, pertaining the prosecution's next submission regarding Lord Blaze's duty to remain informed of the situation simply because he had signed the executive order. Now, in this regard, while there are indeed general obligations imposed on superiors, such as Lord Blaze, failure to adhere to them does not result in liability. This was held in a 2016 case of Bemba by the accused chamber. This is because a superior's mere negligence in remaining informed is insufficient to result in liability. And instead, liability only arises if a superior has failed to act despite already possessing knowledge and conscious disregard. And we emphasize again that in this regard, the relevant mens rea has not been proven.
Counsel, what do we make of the reference in the intercept by Lord Blaze to, first of all, the numbers of individuals in detention and the fact that he has ordered the release of 10,000? Even if that doesn't refer directly to knowledge of the crimes, doesn't it show a degree of involvement in the affairs of the detention facilities that is indicative of knowledge of what's going on there?
Yes, Your Honor. However, pertaining to the standard of knowledge which is required, the superior must have knowledge of the relevant crimes which were being committed. And this means that Lord Blaze must have known that the act of enslavement was occurring. Now, pertaining to the people being sent to these detention centers, which Mr. President had pointed out, we note that 30,000 people were in these detention centers. However, we submit, Your Honors, I note that my time is up. If I may just answer your question.
Please take an additional minute, Counsel.
Yes, Your Honors, much obliged. Now, given that 30,000 out of 10 million people residing in Fire Kingdom, which is stated at paragraph 2, is but a small proportion, we submit that this is insufficient to show the Lord Blaze knew about the act of enslavement occurring in these detention centers.
Did the crime of imprisonment occur at these detention centers?
Your Honor, it is our position that the crime of imprisonment did not occur in these detention centers. Now, unless I may be of further assistance.
No, thank you very much, Counsel. Thank you for your submissions. And I'll now call upon the defense to please present its 5 minutes rebuttal.
Thank you, Your Honor.
May it please the court, I will be using half of the time to address 2 points and yield the remaining half to my co-counsel. On our first point, with regards to the defense's understanding of enslavement and the conditions that are required in order to prove enslavement, The defense has taken a very narrow approach to how this crime can be proven. The prosecution submits that this should be a case-by-case analysis. The defense mentioned that conditions have to reach such an inhumane extent in order to prove enslavement. However, the prosecution would like to direct Your Honor's attention to cases such as Natanga and Katanga, where enslavement, sexual slavery was found, and the victims were made to carry mattresses along very long distance, and they were made to carry out chores for the soldiers. There is no mention of how harsh exactly these conditions have to be, and the prosecution submits that those two aforementioned cases are analogous to our situation. We didn't understand what the defense wanted. If for them it would have sufficed that there were actual victims who had died, then the prosecution submits that it is no one's wish that we reach that level. On our second point with regards to admissibility, the defense mentioned that there was a national trial and that the ICC should operate in complementarity to national criminal jurisdictions. Criminal is the key word because law number 14 allows for a trial if amnesty is not granted. This clearly shows that amnesty does not mean a trial. And having a criminal proceeding only with regards to those that do not receive amnesty carries with it the very, very heavy risk of giving amnesty to people who are guilty of crimes against humanity. I will now yield to my co-counsel for our last rebuttal points, if I may be of no further assistance.
Indeed, Your Honors, I have 2 points of rebuttal. The first is that the defense has said that the AANG was involved in the peace process, and as such, the victims received justice. Now, we submit, Your Honor, that that is a non sequitur. Paragraph 17 of the facts note that the negotiations were between the AANG and the BNS. As was highlighted in the prosecution submissions, there were civilians who were in center rig, and where those civilians were omitted from the considerations of the Truth and Reconciliation Commission, then we submit that those civilians could not have access to justice. And it is further imperative for this court to prosecute Lord Blaze in their interest. Further to that point, the defense has established a false opposition here.
Counsel, just on that point, can I quickly ask you to respond to the South Africa example? After all, it was the ANC and the government surely that negotiated the Truth and Reconciliation Commission process. Is that a reason for saying that there wasn't enough public involvement, therefore the amnesty should be disregarded or rejected as a peace process or as a judicial process sufficient to satisfy the definition of a trial?
No, Your Honor. In fact, we submit that the question is not necessarily one of public involvement. The question is one of efficacy and whether the commission achieved its purpose, and we submit that it has not, for the very reason that the absence of any consideration at all regarding civilian welfare was excluded. And in any event, Your Honors, we submit that even if the Truth and Reconciliation Commission was indeed efficacious, it does not exclude Lord Blaze's prosecution, considering that the Truth and Reconciliation Commission does not act in opposition to a prosecution, as was highlighted in 2001 with the prosecution of Joseph Kony, that a prosecution can happen and indeed be successful while reconciliation can happen while there is a prosecution. On my second submission regarding criminal responsibility now, the defense has conceded that there is a superior subordinate relationship. And in fact, we submit that the latter prong of knowledge stands, considering that conscious disregard is still met on the facts. Now, we, the prosecution, highlight, Your Honors, I see that my time has expired. If I may,
please take an additional 30 seconds, counsel.
I am much obliged. And we submit that the defense has not tackled The pertinent question of conscious disregard, in fact, we submit that actual knowledge is not the only requirement. And where it is that Lord Blaze, having established a framework of giving an order of take all necessary steps, but not acting in accordance with his own higher requirements suggests and notes, and we submit that this is evidence that there was conscious disregard, Your Honors. For these reasons, we submit that this court should proceed with the prosecution of Lord Blaze. May it please the court.
Thank you very much, counsel. And I now call upon the defense to present its rebuttal, please.
Your Honours, 2 points in the rebuttal. First, we do accept that there is a tension between both the domestic amnesty granted by the courts and the state's international obligations. However, this tension is already resolved when we assess the amnesty using international standards. And the international standards in this case are already those captured under Article 17(1)(c). And this is what my co-counsel has previously addressed Your Honours upon. Now, second, in relation to the fact that the prosecution argues that the Eng was involved in the peace process but were not actually the victims themselves. Your Honours, we acknowledge that the victims in this case do indeed include both the Eng and the wider population. However, the destabilization of the peace process affects this wider population as well. Because the very fact that the peace process is destabilized could potentially cause the country to turn back into a politically turmoilous country. And this would also be disadvantageous for the broader community. And in fact, the prosecution even brought up the case of Joseph Kony. However, in the case of Uganda, it was precisely because this court had granted an arrest warrant against Joseph Kony, the head of the LRA, that peace negotiations broke down. And subsequently, what occurred was that the conflict resumed and the lives of 1,000 civilians were lost just the next day. And this is a point which the prosecution had failed to bring up earlier on. Now, Your Honours, the current situation has resulted in much instability and suffering on the part of both countries. As such, we urge this court to dismiss the current proceedings against the prosecution. As the 5th Nuremberg Principle states, all individuals should be subject to a fair trial. And in this case, we submit that there are no grounds to believe that Lord Blaze is individually responsible for the crime. Hence, the defense humbly prays for the current proceedings to be dismissed. Now, unless I may be of further assistance.
I see no questions from the bench.
This concludes the case for the defense.
Thank you very much, counsel, and thank you very much to the parties for their very helpful submissions today. The pretrial chamber will adjourn and deliberate, and we will return shortly with a ruling.
So I will now send the judges to the deliberation room and the teams to separate breakout rooms.
Welcome back, everyone, to those in and around the courtroom. What I'll do is I, as the presiding judge, will speak on behalf of the other judges, Judge Schomburg and Judge Seoane, about the comments that we have, and then at the end of giving these comments, I'll announce who won the round. And I just have a few comments. All of you have been through a few rounds now, so you've heard some comments before, but there were a few things that jumped out of this particular round that the judges commented on in our deliberations. I think that a very important issue is concessions. Concessions can be a very, very powerful tool for the defense. They can help to sharpen up and focus the case, and to ensure that the case is discussed on the grounds that really matter and those that are essential for proof in order to convict an accused and put them in jail and take away their liberty, sometimes for many, many years. And judges have limited attention spans, and ensuring that you are discussing only the issues and focusing on the issues that are most important is extremely important for the defense. On the other hand, concessions can be a very dangerous thing, because if you concede the wrong point, then actually you'll find yourself in deep trouble and arguing more extensively, not less extensively, about certain issues. So without going into more detail, I simply would say that it's very important to think about concessions, how they might affect individual criminal liability, as well as the strength of the argument of either side. The second thing is, it's very, very important to focus adequately on factual issues that are in play, notwithstanding the very low evidential standards that apply to a preliminary hearing, and in fact, perhaps even more, because there is a somewhat lower standard of proof in a preliminary hearing. That doesn't mean you don't talk about facts. On the contrary, it's very important to bring out those facts and to highlight the extent to which another side may or may not have presented the prima facie factual basis for certain legal findings. There's nothing wrong with tackling that, and they should be tackled. Connecting the facts and the law, even at this stage, is important, not only at a trial. So this is another point that came out during the judge's comments, and it was felt that some of the discussions were very legal, but in a bit of a vacuum, not sufficiently moored to the facts, and in a little bit of a vacuum. And this is related to a third point, which is, it's extremely important in this setting and in any setting, any litigation, to really listen carefully to the other side's submissions, and not merely to present the pre-prepared argumentation. This is important for both sides. And there were some opportunities for criticism, or at least comment on the other side's factual submissions that may either have been inaccurate or may have been taken too far, and that would not only assist in clarifying the case, but credibility is an incredibly important thing in litigation, and in criminal litigation especially. If one side is caught out making cutting corners or not being completely straight on the facts, this will lead the judges to scrutinize much more closely the rest of the submissions. So even taking the opportunity to point out a factual error or something that's unsupported by the other side can be very important to the broader tactical considerations of a hearing. Contextual elements. The bane of many lawyers' existence in international criminal law. The judges felt that there was perhaps an insufficient discussion of exactly what are the contours of acts that can count in determining whether or not there's been a widespread or systematic attack. And that's not purely an academic comment. It's also, it leads into a tactical consideration and a persuasion consideration, which is that it does open the door to arguments that go beyond the four corners of the charges. And this is something that you'll see in every case that happens now at the ICC. And there is a very, in the view of the judges, there is a fairly clear definition as to what contextual elements what forms of, what acts can count as part of crimes against humanity. And I think that the problem sort of set up an opportunity for a fuller discussion of those contextual elements, and then a more elaborate discussion of the facts on that count. Latest jurisprudence is important. The jurisprudence of the ICC is not exactly voluminous. In comparison to domestic jurisdictions, it is an infant. So it is all the more important for that reason to really make sure that the most recent jurisprudence has been reviewed and that the current state of the law is being put forward. There were a few cases where a few occasions where the parties relied on somewhat older jurisprudence, and it was felt that it's very, very important to bring that up to date. And the last point is a positive one. We really did feel that the arguments were extremely well structured, very easy to follow. There was a direct clash on a number of points that were illuminating, and overall, it was a very high quality round, as one would expect in the semifinals of the Nuremberg Moot Court competition. Having said all that, there at the end of the day has to be, unfortunately, a winner. And well, that's not unfortunate for the winner, but it's unfortunate for the party that hasn't won. And in this case, the judges felt that it was the prosecution that carried this round. So thank you very much to all of you for an excellent performance and handling the pressure so well in this round, and wish you all the luck in the future of this competition and more generally. So thank you very much.
Thank you. And congratulations to the defense team for such an amazing round.
Yes, thank you very much to the defense team and to the judges and the organizers as well.
Thank you.